So today we're going to talk about the case of Amanda Lewis. And the thing that's most interesting about this case is that her son is the key witness in testifying against her. And at the time of the event, he's around 6 years old and eventually 7. And I thought about this myself as a mother. Would I let my son, who's that age, be the star witness, like in prosecuting someone in a capital murder case? And I talked to my son about this actually briefly, and I don't think I would have allowed that. Think about the pressures of that child and all of that goes into that for a 7-year-old to be the leading testimony in this case. And so we're going to get into this today. So, of course, we have my favorite forensic psychologist, Craig Wetterer, who I work with all the time. And he's also a licensed attorney and he can contribute a lot on this case and is also a retired police officer. And Nick Leigh Hunt, renowned author and crime historian. Yes.
Renowned. Thank you, Jane. I've moved up. Brilliant.
Yes. Yeah. And author of I Don't Like Mondays. So, which is episode 34, if you want to listen to, just he's very well researched on everything, which is why I want to sit down with him today, because I want to hear from him about this case. Other people have covered it before, but I always say the devil's in the details. And so I would love for you to start us off and tell us about this case.
Yeah, for those who know me, they know that I love the detail and I just get going. And I've been really interested in speaking to you and Dr. Craig about this, because it's one, like you say, a 6-year-old is the star witness against their mother. Let's set the tale first. Let's do a quick sort of just catch you up to speed of what happens here and how we got to the situation where a 6-year-old is testifying against his mother. This is Florida, northern Florida, right on the Alabama border, 2007, middle of summer. Kids are playing outside in an above ground pool. Mom's inside doing laundry, taking care of business. She works the night shift. She came home early, took a nap, got up. Kids are kind of running around doing their own thing. It's AJ 6 and her older sister, Adrianna, who's 7. They live in a double wide trailer. I've lived in England too long. I actually had to Google what that was, but I guess Americans will know what a double wide trailer is. It's sort of one of these. It's a mobile home, but a very nice executive one. It's a good sized one. It's fairly well kept. There's lots of them that scatter northern Florida. The kids are playing outside. They're told to never leave the perimeter of the house. At some point in the afternoon, Amanda Lewis, the mother, she's a 27-year-old single mom who lives there with her boyfriend at the house. Her boyfriend's son is asleep in the bedroom well into the afternoon. He sleeps through the whole event, doesn't hear anything. Amanda goes to the front door, asks AJ where his older sister, Adrianna, is. They can't find her. She walks to the back of the house, or she says she walks to the back of the house, and AJ runs around the house. They find her floating in the above ground pool. It's one of those rubber blow up pools, 18-footer, pretty big, holds about 6,000 gallons. She runs outside. She pulls Adrianna from the pool, leans over the edge. She's quite tall, Amanda. She's 5'10". She's quite tall. She pulls Adrianna out, puts her on the floor, begins CPR. She knows rudimentary CPR because she works in a care home overnight. She's freaking out. She calls her boyfriend who's at work, then calls the paramedics. They arrive within 3 minutes. They're only around the corner. The first responder who arrives knows the house, knows the boyfriend, knows Amanda, has been in the area. It's all quite a small community. Sadly, Adrianna is airlifted to Bay Memorial in Panama City, about an hour drive away, quick helicopter ride. She passes away, sadly. But it's in that interim between Amanda being at the hospital waiting for results on her daughter, who briefly gets a pulse but does pass away. The little 6-year-old boy, AJ, is inside the house watching cartoons with his mother's boyfriend's son. And he's picked up by his grandmother and his step-grandfather. We're just going to call them Brenda and Pa Chuck. They're the grandparents of AJ. And they drive him back to their place in Alabama. It's only half an hour away. But Brenda's locked her keys in the car. Of course, she's distraught. Her daughter's been taken to her granddaughter's been taken to the hospital. It's quite an emotional scene. You can imagine what that must have feel like. Let's remind ourselves also that the number one cause of death in Florida for children is drowning. So the scene is all too familiar for the paramedics, and the parents obviously are distraught, having never seen it before. It's quite an amazing scene. You can imagine how horrible it would be. In that drive that Paul Chuck takes with AJ, the 6-year-old witness, this is his step-grandfather. In that drive, apparently, AJ reveals to the step-grandfather that his mama did something to Adrianna and drowned her. So as soon as Brenda gets to the house, this is the grandmother, Paul Chuck tells her, hey, I think something's happened here. We better call the police. He calls the police right away. The sheriff says, why don't you come back to the police office? They come into the police office, and before you know it, they're sitting in an interrogation room with AJ. The mother, unaware, is at the hospital in Bay City with the grandmother and the step-grandfather. They begin this conversation. In the conversation, this poor 6-year-old is now wearing a crisp white new T-shirt. The grandparents had changed his clothing from the crime scene. He's now wearing brand new clothing. His clothing was never submitted to evidence. We have no idea what connection he had to the scene. He's sitting in this sheriff's office. And the interesting thing about this is he's surrounded by the two police officers with the camera directly in front of him. Behind him is a big TV screen. This is 2007, so they weren't flat screens, but they were one of those big, you remember the old days of TV. You can see in the reflection, you can see Paul Chuck is 2 feet from him on his right side, and 2 feet on his left side is his grandmother, Brenda. He's literally surrounded by these adults. There are no child protection services officers there. There is nobody trained to speak to children. He is not a suspect. He's a witness. And they just start asking him questions. Then they pause and ask him, stop. They then start the recording on the video and then say, pick up where you left off. And he just starts again. And he tells this wild story of how his mother drowned his sister. And, at one point he says he didn't see it. Another point he says, I heard it, but didn't see it. Actually, about 8 times he says he didn't see it. And in fact, I've listened to this tape closely, and at not one point does he ever actually say he saw it. But also, interesting enough, at not one point did the police actually ask him what he saw. They said, tell me about your mama drowning your sister. So right away, I saw this video, and it just raised the flag. Well, hold on a second. Uh, that can't be right. I couldn't imagine what my 6-year-old child would say. I mean, my children are much older now, but I couldn't imagine what I would say at 6 years old, or what a 6-year-old would say when being presented with, tell me how your mother drowned your sister. So the grandmother is gobsmacked by this, and she becomes overcome with worry and stress, and gets up and leaves the room about midway through. So now the boy is surrounded by no blood relative, no actual legal guardian, a 6-year-old by his step-grandfather of no blood relation, and 2 untrained sheriffs with weapons. Okay? So to a British person, this is just breaks all the rules. So we were shocked to see this when we watched it as a group of us. Anyway, at that moment, the cop then asked the question, so show me how your mama drowned your sister. And he puts his left hand to his face and says she held her face back like this and drowned her. Okay, so the police thinking, oh poop. They get in the car, they drive straight down to Amanda. They speak to her at the hospital. The doctor says, hey, there was a bruise on the forehead. That could have been from a number of things. It could have been a week ago that happened. Bruises. Again, doctors know more about this than I do, but from my rudimentary study, bruises are kind of nondescript. You can't tell exactly when they happened. The cops determined that it is a fresh bruise and it must have happened during the event. They speak to Amanda at great length. They go back to the house. They do. Long story short is Amanda is eventually arrested after the coroner determines that could be, in fact be a handprint on her face. from pressure, not from blunt force trauma. He also concludes that the child, the 7-year-old who drowned, had petchia, sorry if I mispronounced that, of the eyes, which could indicate strangulation. Now, my rudimentary study also shows that anybody who exerts a lot of energy, like drowning in itself, could cause this, or fear could cause that petchia in the eyes. So on these two pieces of evidence, which was the child saying that he thought his mother had drowned his sister, never actually saying it, and then this bruise on the forehead and possibly spots in the eyes, they're able to gain a coroner report to confirm that, and then a search warrant. Um, they conclude also there was sadly some blood in her shorts, and there was blood on the side of the pool, and they decided that it was sexually motivated, and they then inspected the house a second time for possible some sort of sexual misconduct. So it was a full investigation from the moment that AJ spoke. In the end, it goes to trial. AJ is asked to testify against his mother, which he does. Within that testimony, he is describing a picture that he drew 2 days before the trial. He's now 7. This is February from the August, so it's 6 months away. He drew the picture 3 days before trial. It was edited by the prosecution. The entire time he gives his testimony, the prosecutor is standing behind him with both arms around his shoulders in front of the large screen. It does feel odd to me. The whole thing felt odd. And then in cross-examination, he actually says he did it. He says he pushed her in the pool and held her legs. In the end, it didn't seem as if in the end, his testimony is 14 different stories he tells. It's quite remarkable. Amanda is charged. She's charged life in prison without the possibility of parole. She is still serving in a Florida prison for something that, look, I'm not going to say she's innocent or guilty of what happened there, but I will say she certainly did not get a fair trial. They plea bargained down from a 12-person jury to a 6-person jury to take the death penalty off the cards. 2 of the jurors walked away at the end of the first day. A 3rd juror announces right before closing arguments, that my daughter-in-law knows the boyfriend. So he's excused, and so 3 of the 6 jurors are alternates. And she's convicted within an hour and 45 minutes over lunch with the sheriff in the deliberation room. So there's a number of things just made me think, hold on a second. This is all recorded on court TV. You can watch it. It's a well-known case. 2020 have done a sort of short documentary on it with their hour-long program. Pierce Morgan, Killer Women, episode 2. You can find it on Netflix. Aphrodite Jones, a few years later, went down, even spoke to a couple of witnesses who recount information that didn't happen in the trial. So the whole thing from start to finish just stinks for me. That's the story. And I know, Craig, you watched part of the documentary, and in 35 minutes or 40 minutes, these documentaries, you can only give out so much information. And there's an awful lot more to it when we start talking about the coroner who did the autopsy and his relationship with the cops. The sheriff was doing press conferences, telling stories about how they found the child that were incorrect. All of the jurors said they had heard about the case in this small town. The defense attorney was a well-respected public prosecutor, Walter Smith, good guy, sat in many cases, very experienced. There was no reason to suggest that he wasn't doing a proper job at the time. I certainly not going to suggest that he's done a bad job, but having a look at the totality of the information that maybe he didn't know then, something looked untoward. So, sorry, I know that's a lot of info. Let's break it down. Let's cut through that. There's a lot of stuff in that, but it's how I roll. You know how I do it. I've got pages and pages and pages of this. We've started a podcast with Amanda. We've been communicating with her in prison. She's got a wonderful team that works for her. She's also being represented by the Georgetown Making an Exoneree program, which is a bit like your Innocence Project, but for Georgetown University. Interesting enough, the professor who is representing her case is also named Amanda Lewis, which is curious to the side. So there's two Amanda Lewises working for this woman's freedom. It's just a remarkable story. The young 6-year-old has never seen his mother again, or anyone in his family or extended family. He was whisked away from her that day, had never seen her again. He was foster parented and then adopted, and is now he's an adult. He's in his early 20s. He's finished school. He's soon to get married. He seems to be doing quite well in a community that's not far from Esta, Florida. Amanda's still in prison. Sorry, guys. Take it away. Now, questions, I'm happy to take them and go into some more detail if you want.
No, I appreciate all that. One of the things that sticks out in my mind as a psychologist, I interview people, including children or adolescents, and I have to have permission from their biological parents to do an evaluation. This could be for child custody or other court cases, right? So in this situation, there was not permission from their legal guardians, and I wouldn't conduct the interview. And yet they did. Grandparents
Again,
didn't have legal.
it comes down to training. I think the police officers didn't have the proper training, but you're trained to know the difference of right and wrong in this situation. And I would think if anybody was brought in, sorry to cut you off, Dana, but that surely anybody, right? Am I wrong here? Or
well, so let's take it to the investigative side and focus specifically on the interview of this witness, this child, right? Nick, Leigh, you mentioned that what I heard you say were a lot of leading questions. In this interview, and what a leading question is just a question that suggests the answer, right? So, for example, when you said, show me how your mom killed, right, your sister or half sister in this case. That's a leading question. So one of the things and I didn't see this in the documentary. I watched the Piers Morgan documentary, by the way. That's the one that I saw, and they did have excerpts of some excerpts of the interviews, but I don't think it didn't show the entire interview. So I would be interested to know, and you may know this. It sounds like these interviews, or the interview of the child, was not done by a forensically trained evaluator. In other words, usually, child witnesses or child victims who are victims of, violent sexual assault, those sorts of things, they go to an interview center in most jurisdictions where they're interviewed by people who are trained in, child developmental psychology and such. And I don't think that happened here. It sounds like these were just regular sheriffs, either investigators or detectives, or they could have just been sheriff deputies who were not even investigators. But he was interviewed at one point in time, and it sounds like there was a lot of leading questions being asked of him. And again, with a child, the problem with that is that when you ask a leading question, you're creating a narrative in that child's brain that suggests an answer that they're looking for. And children, just by virtue of being children, often they aim to please. So, if they are being sort of directed in a certain way through leading questions, you're going to get an answer that may not reflect the true reality of what happened. So that's the problem with leading questions. Now, how much of that did you see this in the actual interview? It sounds like you did. You saw you watched these interviews over and over again, correct? And you saw these questions.
Yeah, I have
being
the
asked.
video. I have the video of the full interview. I also have most of the interview. She was little AJ was in a child services interview later that evening, about 9:30 p.m., which is 2 hours after his bedtime. He was interviewed a second time. And her name was, she wasn't a doctor. Her name was Sarah Campbell. She's trained to the legal specification within Florida. She's not a doctor. She's not an expert within this type of discussions. But she concluded that it was hard to know what AJ actually saw. He said so many different things, and none of it was clear. So she testified to say we couldn't determine what it was he actually saw. But the jury went with what the police told them rather than what AJ actually told them. So I think as much as we want to say that the police put AJ in an uncomfortable position, and he was in an uncomfortable position. And because he was awarded to the state, the only people they had to ask was the child services if he could testify. And there was no way that they were going to go against what the prosecution had already decided. So from the moment AJ was taken from his mother, they never had to ask her any permission.
They don't. Yeah, they don't.
Yeah.
By the way, because once the child is in the custody of the state, essentially, right, they become sort of the guardian ad litem, basically. So the state then becomes the guardian of the child at that point in time, and so that they have the legal authority to, act in the best interest of the child, and especially in a case like this, where if again his mother is the suspect in this case, right? So they're not going to need permission from the mother in order to conduct interviews or anything of that sort.
Quick question
in this
on that,
circumstance.
Quick question. Now, I'm not an authority on Florida law, and I know you guys are a long way from Florida, but Amanda wasn't arrested for a month after the incident, but AJ was taken that day. And the next morning, they held a little court hearing. They all went to court to discuss it.
Yes. Yeah.
And because all of Amanda's family lived 5 miles away over the Alabama border, they were refused custody of the child.
Yeah, that's interesting.
If Amanda would have had money to retain a defense attorney and never even spoken with the police, like this all would have played out differently. She has rights.
Well,
they can't take
there was no note of her Miranda being read until a month later.
So
look, look, you can get this. These are small town folk. I'm not uneducated, but these are small town folk who trust the police.
Yeah, I'll speak to the Miranda issue. So Miranda only attaches, and you may or may not know that Miranda only attaches when an individual is in custody and law enforcement intends to interrogate them. It's a two-pronged test. So custody plus interrogation equals you must Mirandize. So if she was not in custody when she was interviewed, because I think you said that they may have interviewed her. Perhaps they interviewed her in a interview room at the sheriff's office. That's oftentimes what they do. Generally, they'll give an advisal at the very beginning, and they'll say, you're not under arrest at this time. You're free to leave at any time. In other words, making it clear to her that she's not under arrest, and they won't give a Miranda warning at that point in time, and they don't have to give a Miranda warning because she's not in custody, right? They are interrogating her, right? They're interviewing and then interrogating, but you have to have custody plus the interrogation for Miranda to actually attach. So that might be what happened.
And she certainly, the first 2 times she was interviewed, she certainly didn't think that she was under any suspicion at all. Mm-hmm. They just asked, "Hey, what happened? We're doing a follow up." And I think that's all above board.
Yeah.
At the end of the second interview, one of the sheriffs drops in. "I don't know why your boy would say that you did something wrong to your sister. Do you have any idea why your son would say that?" And then you can almost hear that's only recorded. You can almost hear the penny drop. She says, I have no idea why my son would say that, And then they say, "Would you like to take a polygraph?" And she goes, "I'd love to." Yeah. She passes that polygraph.
Yeah.
She passes the polygraph. And at that point, she still went in for a third interview.
And she didn't. She wasn't she wasn't represented by an attorney at this time. So, like what Dana said,
she hadn't called one. Again, she was still disbelieving the situation.
Yeah, I mean, had she had resources, right? Had she had money, right? She would have called, an attorney or gotten an attorney and said, "Hey, the police keep, they want to question me again." The attorney would have probably, advised her at this point, no more. You're not going to, you're not going in for any more interviews. Just politely, decline the interview, and you're within your right to do that in the United States, just because you don't have to talk to the police about anything, right? If they come up to you, even on the street, and want to have a conversation, you can politely say, "Thank you, but no thank you." So she, of course, didn't know this, right? And she probably thought, again, I'm innocent, so why should I not talk to them, right? And a lot of times people feel intimidated by law enforcement. They think that if they don't talk, that's going to create a cloud of suspicion, right? That, they're not talking. So So a lot of times people feel the pressure to want to talk. They want to clear themselves. They want to,
She had nothing to hide. In her mind.
And that can happen, right? But, generally, if she would have contacted an attorney, the attorney would have, talked to her about, okay, these are the risks of you actually going into an interview. And even if you did decide to go and talk and give a statement to law enforcement, you would generally be represented at the time. In other words, your attorney's there present with you, making sure that you're not, you're not going down a rabbit hole in an area that's going to get you in trouble. So, but she didn't do that. I mean, she didn't have that resource available to her because she's not going to get a public defender until she's been arrested and charged, right? And then the first, adversarial proceeding starts. Then that's when you are entitled to counsel. You're not entitled to counsel necessarily before that, before you're arrested.
So everyone before she was arrested was interviewed. In fact, they called no new interviews after the arrest. So they did almost all of their investigation, 90% of it, before she was arrested. And she's very trusting of the system. And again, I'm on. Let's go with the assumption that she's guilty, right? Because she was convicted, and I don't know what the truth is. I just don't know. But she certainly didn't get a fair crack at it. She wasn't told exactly what her rights were at any given time. She followed the procedures that were given to her. Her child was taken away from the entire family. They've never seen him again. So the 6-year-old, so on that same day, and it's heartbreaking, on that same day, she loses this child. She's clearly distraught. She's, some said that she was so, so distraught that she was showing no emotion. And I think there's a reason why. Because about 10 years before then, she lost her first child who had seizure while he was asleep. And he passed away, and it was a known ailment that he had, and the doctors were aware of it, and he passed away. But some of the family members in her family, especially Paul Chuck, felt that she had something to do with it. So Paul Chuck, now let's remind ourselves, he is the step-grandfather of the key witness and of the victim. No blood relation. He faxes over the autopsy report and some other information about this child to the police. I have a copy of the fax that he sent. It has his phone number and his, remember faxes? Remember the old days when you fax stuff? It actually prints at the top of the page who it's from and the phone number. Yeah. Well, it's from him with his name and his fax number at the top of this page 2 days after poor Adrianna drowned in the pool. So he's assisting the police in this prosecution of Amanda.
Yeah, he's setting the stage. Yeah, setting the stage.
Yeah, so it starts to raise that question of this involvement from the family. The mother becomes a witness for the prosecution. I asked her, I spoke to her on the phone last week, and I said, Brenda, why would you become a witness to prosecution? You clearly could have said no or said anything. She said, I didn't know what was prosecution or what was defense. A man in a suit came to my house with a paper, told me to come to the court. I came. It was my daughter on trial. I thought, I'm going to tell the truth because that's what we're told to do. And somewhere within her testimony, she testified that the daughter was afraid of water. And therefore, the prosecution had concluded there was no way the daughter would have gotten into the pool on her own, despite the 9 other witnesses that said that they went swimming with her. It just the way it was, the way the message was told, it was woven in a way that was very clever. And I think I think the jury knew a bit about the case beforehand because, again, more detail. Sorry, guys. 4 or 5 days after Amanda was arrested, the sheriff starts talking to the press. And he says, well, we arrived at the house to find the daughter in the pool, which was incorrect because actually Amanda had taken her out of the pool and had started CPR. But he had told the newspaper, which was repeated. I found 13 independent sources for that, AP being one of them, and the local broadcast news being another. So it was on television and within the Associated Press. He also says that Amanda sent her son to go around back and find the daughter in the pool. Now, contextually, that's not untrue, but when put into the article of the child being found in the pool, it makes it sound as if Amanda had drowned the daughter, gone to the son, go get your sister, she's in the pool. So when you read this article, and incidentally, that's exactly what is repeated by one of the jurors on the Aphrodite Jones show. which is curious because it's nowhere in the trial. I've read the entire transcript. I've watched the trial. It is never mentioned that way in any way, shape, or form. So it leads me to believe that the jury, so we went and filed the Freedom of Information request, and Florida is a sunshine state, so it gives you everything you ask for as much as it can. I've got the jury tapes of the jury selection. Lo and behold, 5 of the 6 jurors who sat on that trial, they read about it in the newspaper, heard about it at church, saw it on TV. After the first day of the trial, 2 jurors say they're sick and can't return for the 3rd day.
So alternates come in.
On the 4th day of the trial, in the morning, just before final statements from the attorneys, and one of the alternates says, well, I just found out that my daughter-in-law knows the boyfriend and knows the family really, really well. And I thought I'd just let you know that I know them.
Yeah.
So
why
then
is
the
this
judge
not a mistrial?
Well, that should have come out in voir dire. Yeah.
So then the judge says, why don't you go back to being an alternate, and we'll bring in the final alternate, who is an 18-year-old who probably wasn't paying attention. We've spoken to her, and she's really nice. But she says, I wasn't really paying attention. I was a juror. I was an alternate. I didn't even think I was ever going to be called. She's called in like literally 2 hours before they go to convene to make, before lunch, they finish their sandwiches and convict her. Life in prison without parole.
So
it was like, it really was. I mean, I don't think I've ever seen a faster trial.
Yeah, usually when it comes back fast, that's not a good sign for the defense. Generally, it's a good sign for the prosecution. But
you watched the Piers Morgan special. I would have thought Piers Morgan would be all over that part of the story.
Yeah, exactly.
But I don't know if it's been revealed. I don't know if the full context. And so we're trying to say, hey, look, this one is deeper. This is pretty stinky.
I'm not an appellate lawyer, but I'll tell you that like what you're describing, some of these circumstances are generally, these are not harmless error sort of things that are happening in the procedural, process of this trial. And oftentimes, so in order to get a new trial, you generally have to demonstrate that there's error in either the procedure, in terms of what the defense counsel did, or there's some misconduct or some, something procedurally that wasn't followed, consistent with the either if it's a federal case, the federal rules, or the state statutory procedure. And oftentimes you can get a new trial, granted on that basis. So the question I would have is well, because of this community being so small, and this county is a fairly rural county, right? It's kind of on that border. It's not a small. It's a small county. Was there a change of venue motion ever made by the defense at any time? And then if not, why? Like, why would they not do this? Particularly if you have the entire community knows the intimate details of all of this. They even know family members and that kind of stuff because it's such a small community. I would think that a change of venue motion would have been appropriate.
The change of venue was never considered. And I think it's unclear why it wasn't.
Well, that's, so that's the...
I think, when I spoke to Walter Smith, who was the attorney for Amanda Lewis, I said, why didn't you apply for a change of venue? He goes, there was no evidence. He said,
yes, it's right. And that's true. You have to have, evidence of bias or some inference. So for example, in the Koberger case that's going on right now, they're trying to get a change of venue because of all the media press and all of the, in the local jurisdiction. The problem is that this is that's a national story that, most people have at least heard about this, but to the extent the details, it's unclear. But a case like this, maybe I know it was in the news media. It was in the local news media for sure. I'm not sure how far it got into the national press, but I don't know. So had he known that information, that you just spoke about, right, regarding these jurors, had he known that at the time, maybe he would have been able to do that. Is what it sounds like.
Yeah, I don't think he was fully aware. And again, I don't think it was made clear to him. I also want to add some side note to this, if I can go even deeper for you guys, because Ben Crump plays a role in this.
Oh, okay, yeah,
okay.
Yeah,
now
he's a high profile lawyer. Right?
He is now
Yeah, well, yeah, but back then he might not have.
But in 2007, he was representing the family for Martin Lee Anderson, who was a 14-year-old who was sadly, a horrific case. He was at one of these teenager boot camps in Florida, and he was beaten to death by the guards. Now the coroner initially said it was sickle cell, that this child who was 14 had died from sickle cell and not from the beating. And Ben Crump was hired by the family. And he came in and said, well, look at this autopsy. The kid had all kinds of bruises, abrasions. He had smelling salts up his nose after he passed away, which was a technique to revive,
Yeah,
there's a 14-minute video of the guards beating this poor kid. This is a really horrible crime that happened in Florida. So Ben Crump comes in and says, this coroner who did this is an idiot. And in fact, he actually goes on record to saying that if you look at this coroner's record in the 14th District of Florida, his name is Dr. Charles Siebert. If you look at his record, the first time might be a mistake. The second time is a problem. The third time is a pattern.
Yeah.
The fourth autopsy he did was the one on Adrianna Hutto, this poor child. So he was thrown out as the coroner for this district of Florida. He was told to never come back. Then they were told that the law in Florida is you must have a coroner at all times. So they brought him back for one more autopsy, which he did this autopsy on Adrianna Hutto, saying that she had a handprint on her face, and then promptly left the state. So he never testified in court. Instead, they had nobody who actually was at the autopsy testified, except for the secretary of the medical examiner's office, who had no medical training, hadn't even graduated high school. And she's the one who famously stands in front of the jury and says, I was able to put my hand on the face of the child and determine that it was a handprint on her face, and the mother must have done it. And that's how we conclude from the autopsy, is that it's murder. And it was that moment, regardless of what AJ had said, regardless of what anyone else had said, here now you have a medical, I'm going to say expert. I just did air quotes. I can't believe I did that. Here you have a medical expert saying it.
This is a secretary.
Not.
She's a secretary.
Essentially.
So this is
she's admin. She's not necessarily secretary.
Yeah.
I'm not going to degrade her position, but she is essentially an admin, head of the investigation admin part of it. Yes, she's not a medical trained.
She's not a physician. She's not trained as a medical doctor, trained in forensic medicine.
And it goes deeper. Her name at the time was Lisa Ruckman. Before that, she was Lisa Forehand. Before that, she was Lisa Dietrich, who was a convicted felon for lying when she was 14 to get a driver's license. She submitted false information. She has a background. And since then, she has quite a fairly consistent criminal background after that.
Yeah, so there's credibility. There's huge credibility issues with her.
But it was an unknown at the time. And even the cross-examination by Walter said, hold on a second, why are you even here? Why is she? Are you a medical professional? No. Do you have any medical degree? No. Did you even graduate high school? No. So do me a favor. Put your hand on your forehead. So she does it. And he says, now press hard enough to make a bruise. Can you do that? And she says, no, I can't. He goes, well, maybe the bruise on the face was your hand, since it fits so perfectly. And he kind of made a mockery of it.
Yeah.
But the jury kind of didn't grab it. They just didn't. The damage was done, I think, at that point. It's a remarkable case. It really is remarkable.
Yeah, I had no idea about this. This is shocking that again, someone has no medical training whatsoever would even be again, I'm not the judge in this case, but let's just say I was the judge. There's a voir dire process. Voir dire is a process where both sides get to examine that expert, because this is an expert witness we're talking about. They get to examine that expert witness to determine if they actually have qualifications that meet the standard of an expert. Now, I'm going to tell you that the qualification to be an expert in the United States court, under both the federal rules and generally in the state, it's actually, the bar is not that high. I'm going to tell you that. You just have to have more knowledge than the average person does in that particular area of expertise. But when we're talking about drawing inferences or conclusions as to causality of, say, a medical condition or something like this. In this case, what caused this marking? That requires an expert who at least would be medically trained, generally at the MD level. I mean, it sounds like she didn't even graduate from high school. So she has clearly no medical training, right? And so I'm not sure how she was even permitted to be admitted as an expert. And that's something that the judge has the discretion, because the judge is the one that issues that ruling in terms of whether that expert can testify or not. So that in and of itself is shocking from what you described.
It's interesting because she is challenged in cross-examination, says,
course.
You're here. Yeah, you're here because the actual coroner who did the autopsy is no longer a coroner in the state. He's actually literally been removed as the coroner for faulty autopsies, right? And we're talking about 30 of them. This is not just like a couple. There's like 30 cases. Right.
So the foundation of this entire the autopsy itself is in question because this coroner who can't be cross-examined by the defense, right, isn't available, right? And so there is is it Ignacio, the case U.S. versus Ignacio? I'm not sure of the case. Again, not my area of expertise, but I understand there is a statute that says you are supposed to be able to confront your accuser in the case of an autopsy. It's a constitution, and there is case law to support this. But under the Sixth Amendment of the Constitution, this is a due process right. You have a right to confront and cross-examine your accusers. This also includes anybody who is, being put on by the prosecution in this case, who is going to act as an expert, which is what you're describing here, is that she's sitting as an expert, drawing a conclusion as to causation, right? When we're talking about this handprint. But the coroner that did the autopsy, from which she's speaking of this sort of the evidence here, isn't available for now. Again, there may be some exceptions to allowing when they say maybe the coroner passed away or is no longer available. This is where sometimes exceptions to hearsay, they can admit evidence into court. There's a hearsay rule, right? And the hearsay rule just simply says that out of court statements that are being offered to prove the truth of the matter being asserted must be attested to in person. That's the hearsay rule. In other words, you can't just rely on somebody's statement taken outside of court. They have to be in the courtroom, be able to be confronted by the accuser. In this case, they're right, and cross-examined. And so, but there are some exceptions to this. So I'm not sure what legal wrangling happened to allow that, but
I think the judge may have made an exception in this case. It appears he did, because they allowed the interim medical examiner. Her name's Andrea Maynard.
Okay.
Sorry.
Yeah.
She became the interim.
The interim
awaiting,
ME, right? Okay.
Because they had to have somebody.
Yeah, correct.
And
so that's an exception.
She very cleverly said, I've reviewed the documents. I did not see the body, but I reviewed the documents. And based on the witness testimony that has been bona fide by the police, based on that, I have no other way to conclude this other than the original findings, which in this case is murder. I have no information to disprove what I've been told. It's almost like that overruling.
All over that, yeah.
You know what? We in Britain we have VAR for our football games. I know you've got the instant replay thing in America, right?
Yes.
So the plague stops and all of the referees run off the pitch for 5 minutes and look at a screen and make some decision. And what they have to decide is, does the video evidence is it enough to overturn a decision that's been made on the pitch? So this is essentially what she was saying. She was saying that there is a credible witness, and that's not for me to determine. The police have determined that this 6-year-old was a credible witness. And because the witness had said he saw, now, first of all, he didn't say he saw his mother, but through the entire court hearing, it's almost presented as if he did, but he never actually says that. Because he saw her do it, and the injuries are vague enough that it could fit that scenario, she had no other means but to say it's possible and I don't have enough information to overrule what these documents from Dr. Siebert said. So that's how I interpret it. But I mean, it might be one you need to watch yourself, and I don't want to take up more of your time, but there's a legality in that is, it's gnarly.
There is, yeah.
It's way bigger than my brain.
Where are we getting these discount coroners like Timu? I mean, this is shocking and concerning.
But Dana, it's not a surprise to you that some coroners work very closely with the prosecution, right?
I am not. This is a historical problem. And let's look at the timeline of this. Conviction, 6 months. The drowning happened on August 8, 2007. 6 months later, February 2008. Come on.
That's fast.
We were just talking about Brian Kohlberger. We know a good defense strategy, like years and years, drag it out. Guess what? All this would have come to surface. This would have come to light, all this information. That's why you don't want to act too quickly, right? 6 months. Yeah, that's incredible. And now it's too late. Once you convict someone, like, take your time. This is serious. Thanks for listening. For episode details and merch, check out killerpsychologistpodcast.com. And for forensic services, you can book online at psychologydr.com. That's psychologydoctor.com.